Hello everybody, here we are recording another video for you on another Tuesday, and yes again, third week in a row, same gray t-shirt here, same gray polo, whatever, no purple shirt. I think I'm kind of putting that aside for a moment here and getting away from that. I want you to see more of what I look like day to day. Well, I do change clothes. I try to be more relaxed, more comfortable. I try not to be your typical attorney by any means. I want to provide a more personable touch when it comes to the legal world as much as I can, and again, provide this education at this platform for veterans, VA, and everybody in between in order to make the process much smoother than what it is today. My ultimate goal is to reduce the number of errors we see, and if that means removing me from the picture, no longer needing me at some point down the road, then I'm okay with that because I've done what I've set out to do. So, for those who don't know, I am your friendly VA accredited attorney, Matthew Lang, here with another topic for you. This one, yeah, let's try that, right? This is another complex topic, and I think VA messes this up a lot too, but I don't feel this is an intentional mess up or necessarily a training issue. I think when it comes to this topic, again, the law can be a little more complex and kind of easy to get wrong. So let me try to simplify it, and we'll probably have to come back to it on another video where I put in more detail. I had it in a lot of detail, and I was going through it, and I'm like, boy, I don't want to put you to sleep any faster than I normally do. So what am I talking about? Well, let's try to understand relevant evidence at that when it comes to like a supplemental claim or appeal. So I have my notes up here on the screen. I've got little talking points set out, so I try to stay on track for you veterans and VA employees and everybody watching. But I'm going to get off track for a second. There we go. Why did I write these, right? We moved from a world of new and material evidence to new and relevant evidence when we moved into the appeals modernization world. So I think it left some confusion when it came to what relevant meant over material. So I'm hoping to kind of clarify that. But I remember even in law school, we talked about what relevant is. What I ultimately got out of that discussion, in short, was everything that's relevant is relevant, and see, I already messed up. Everything that's relevant is not relevant, and everything that's not relevant is relevant. Maybe I was the only one who took it that way. I don't know, but I hope this will kind of make sense in understanding why perhaps that was the perception I had. So I want to see if we can clear this up, because when we moved from what we call the legacy appeal world before the modernization appeals, we had not just appeals, but we had things like reconsideration claims, we had reopen claims, and VA, as part of you at the time, we were all struggling to really understand when to look at reconsideration of a claim. When did that cross the threshold of an appeal? When can we really reopen a claim? Again, was it really an appeal or was it something else? And sure, we did our darndest to get the decisions out and to understand it at the time. But I think the attempt inside the Appeals Modernization Act was to kind of absorb all that into the appeal world in a way. But even then, we didn't fully pull it into the appeal world. We really called it a supplemental claim, which means a supplemental claim, now being part of an appeal, can be filed within 1 year to be an appeal of a decision, or it can be filed at any time after any decision because it absorbed the reconsideration and reopen idea. But when we did that, we did change that terminology from material to relevant. So let me go through my notes here. Let me go through what I've got written up here and see if all this comes together for you and see if this makes more sense in what's relevant. Because VA, I feel like you get confused with relevant, and I totally get it. I totally understand why. Like I said, not probably the easiest concept in law to understand. Just noting how I took it as a young student, young student at the time in law school. So let's get started with the law itself. That's where I like to start, right? The United States Code 38 U.S.C. 5108. Now, this is when a veteran submits new and relevant evidence. The VA is required to re-adjudicate the claim. Now that means the claim isn't just brushed aside. It has to be looked at again, fully and fairly. I do say this because we do see where they get brushed off the side and just said it's not new and relevant. It gets moved on, no explanation of why that is. So importantly, Congress made clear that this new standard is not supposed to be harder than the old new and material evidence. That was supposed to be a much harder standard than what today is. It may not feel that way, but that's the way it's supposed to work. It's simply a different way of framing what evidence is needed to reopen the door, to ultimately reopen the claim. So we got to ask ourselves, what counts as relevant? Well, let's turn back to the regulation of 38 CFR 3.32501. 38 CFR 3.2501. I realize I might have said that too fast. I apologize. So it defines relevant evidence as any information that tends to prove or disprove a matter at issue in a claim. So that's it. It doesn't have to be conclusive proof. It doesn't have to be the final piece of the puzzle. If it makes a fact more likely or even less likely, it's relevant. A little bit, that much, maybe even less than that, maybe even so small you can't even see a space between my fingers. That much of a difference. That's what makes it relevant. So here's a crucial point. Even if evidence that raises a brand new theory of entitlement, you're looking at relevant evidence. So relevant evidence could be evidence that even raises a brand new theory of entitlement. Maybe veterans, you didn't argue the secondary service connection before when you got denied the claim. But now you have evidence linking your condition to another service-connected disability. Well, this counts as relevant evidence. This counts. So it's supposed to be a much easier standard. And a lot of times, just to put it out there, go off my notes, away from my notes again, we see that veterans, when you do claim something, that perhaps the secondary theory door wasn't quite open, and that might be why it wasn't claimed that way. And then ultimately, you got service connected for something that medically is well known to have a secondary theory attached to it with the condition that you've been denied for now. And that door has now been opened based upon new evidence that service connected the other condition. A little bit. Doesn't have to be a whole lot. Just enough to make that plausible link, makes it relevant. Could be a whole different theory. Now we have the broader duty to assist, though. Relevance also shows up in the VA's duty to assist under 38 U.S.C. 5103A. So VA, I want you to kind of note this a little bit closer, because I think when you look at the black letter law and the CFR, you're thinking every supplemental claim means the veteran must provide new and relevant evidence on the spot. Remember, this attaches to your duty to assist as well. This is one other thing that's got to be looked at for relevant evidence. The VA must help veterans get records that are relevant to their claims. Now, the courts have clarified, and the VA doesn't have to chase down every piece of paper under the sun, and I get that. Only those records that relate to the disability claimed and could reasonably help substantiate the claim. So the focus stays on what matters. So I'm going to make an argument here where if we go back and we find the duty to assist failed at obtaining, say, personnel records, and VA, your decision was to deny because there was no event in service, then I'm going to argue that the new evidence is based upon your failure to follow your duty to assist to obtain federal records that may contain relevant evidence showing an event in service. Thus, the veteran doesn't have to provide anything up front because it's not in their custody. It's part of your duty to assist. So the supplemental claim can be reopened underneath relevance as it shows up in the VA's duty to assist. So here's how the courts see it. The courts have weighed in many times. The Federal Circuit has said that evidence doesn't need to guarantee a win. Doesn't need to guarantee a win. It just has to be significant enough to consider. Any little bitty, not much, so thin of a space I can't get my other finger through. Very, very, very little is required. Now, the Veterans Courts have also stressed that the threshold is intentionally low. Even evidence that triggers the VA's duty to assist, like pointing to the need for a new medical opinion, meets the bar. So now I used service treatment records previously, but understand VA. If the veteran gave up on a claim outside of the 1 year line out of sheer frustration, and they come to, I'm opening the door, VA. I'm being transparent to you on exactly what argument you're going to get from me. I'm letting you be prepared because I want you to do better. If I look at that veteran's claim and I realize that that examination was inadequate underneath the rules and laws, and I can justify it, however many years ago that claim was, then the only avenue for the veteran to file a claim is a supplemental claim, despite the fact that there is actually no new evidence or relevant evidence physically to add to that supplemental claim submission. I'm going to tell you that the courts have told you that the duty to assist triggers the new evidence requirement, the relevant evidence requirement, forcing you to go back and redo the inadequate exam. And I will see RBSRs and DROs just completely ignore this. So please, please understand the inadequate exam and opinion issues, because this is a lot of what we see and a lot of what we send to you, VA. Because if that opinion is adequate, or would have been adequate at the time, there's this really little relevant chance it could have changed the decision. And relevancy attaches there too. All right. So the federal court has also said some other things. They've told the VA that they must obtain, again, records that were related to the claim, disability, and could help. But if the records clearly have nothing to do with the claim, VA doesn't need to get them, and we get that. But a lot of times we're not going to know if they have anything to do with the claim or not. So I don't think there's going to be all the time a clear indication. I mean, now, sure, if veteran says that the only treatment he's got at the VA facilities is for his knees, claiming mental, well, you know what? I can't even do that because, my mind up there is going, oh, I might be able to make a connection to that too. So it could be relevant. So I think it's going to be really hard. It's going to be really hard to say clearly. Just to kind of give you a little extra tidbit from the rocks that are moving around up here. But the court did say it. The court's really narrowed the definition in one special context, that newly found service records. Their relevance meant the records had to address the exact reason for the prior denial. But the court later then came back out, the Federal Circuit came back out and expanded the concept, again saying that evidence in VA's possession, like scientific studies, is considered part of the record if it's relevant to the claim. So I think this is where some of our confusion goes back and forth, as the court has kind of slightly slid a little bit back and forth. But ultimately, if it's in your possession, VA, we're also looking at the idea that there could be a bunch of other records that came in after another decision that could be relevant to the one supplemental claim now that's being provided. And that evidence from the past must be looked at too. So ultimately, does the evidence relate to the matter at issue? Whether it had been in there before from another condition, not addressed with this condition because it just wasn't claimed. Are you in possession of it, VA? Do you have a duty to assist to obtain it, to get an adequate medical opinion, all of it that could relate to the matter at issue. So now for you veterans, for you, what does this all mean for you? Well, it means submit anything that links your disability to your service. Now, I'm going to be saying that cautiously because it's not advisory. Your facts of your case are going to be different. You don't want to be just submitting everything and slowing the VA down either. They've got to be able to see that everything is linked together. But if you got medical records, you got lay statements, you research studies, you got new medical theories, these are the times that you want to make sure that all this is submitted is new and relevant, or as we were talking about, relevant claims here, or relevant evidence. In many cases, I tell you not to hold back, but again, it's educational purposes here. Your facts of the case may be totally different, and there might be reason to hold back. There might not be. So if you're not sure, seek out a representative, let them review the evidence for you, including myself, help you out, go on record and put all that together for you. So we're making this process smoother between VA and you veterans. We don't want to get too much extra stuff in there. That slows the process down. And coming back to VA employees, this means that you've got to apply the rules. You've got to be veteran friendly, just the way the law intends. Always ask yourself, does the evidence tend to prove or disprove an element of the claim? Or as I like to say, does it really tend to improve by so much, so little that I can't see between the little fingers there? So minute. It doesn't have to be a whole lot. And if yes, guess what? It's relevant. So I guess everything that's relevant is not relevant, and everything that's not relevant is relevant, because this might be this really little EV chance. You gotta consider new theories too, VA. Consider those new theories. When you make a decision, explain clearly why the evidence is persuasive or not. Just don't dismiss it. We see that again a lot in your decisions. You'll just dismiss the evidence that was off record before. You'll dismiss the duty to assist errors that we call out. Yeah, don't dismiss it. It's all relevant. It's all relevant to the claim. So I'm hoping this short kind of version of relevancy made some sense, especially for veterans and VA. Like I said, I have a much more complex piece back here. I would have probably had everybody shut me off in the first 30 seconds. And I don't want to do that. And if you already have, well, darn it, I hope you come back. But I'm going to conclude with this here. The rule of new and relevant evidence isn't meant to shut veterans out. It's meant to ensure that every claim gets a fair shake when new information comes to light. Relevant evidence is about connection, not perfection. If it sheds light on the claim, even a little itty bitty bit, it deserves to be considered. By applying these standards correctly, we not only follow the law, but we also honor our commitment as advocates, as VA, to those who served, to veterans. So I thank everybody again. Dedicated VA employees, remember, you're making a difference for a veteran. You're serving the veteran now. You may be a veteran yourself. Would you want somebody messing your claim up because they didn't know the rules or the regulations or didn't apply them? I like to think not. So let's do it right. Let's try to learn it. Let's understand it. And let's make it so smooth that you don't need me in the middle. But in the meantime, veterans, veteranline.com. Check me out. Anyways, everybody, have a wonderful Tuesday. I'll see you next week.